Thank you, Chantal and Dr. Chris Parsons for that very engaging opening presentation. I'm waiting for my panelists. Good, so we have our panelists now joining us. I'm delighted to be joined today for this first panel of Regulating the Internet Really, Part 3, joined by two leading intellectuals in the area of internet law to talk about Bill C-11 and the Government of Canada's impending reform of broadcasting legislation in Canada. Just briefly, Dr. Michael Geist is a law professor at the University of Ottawa, where he holds the Canada Research Chair in Internet and E-commerce law. He's completed graduate degrees in both the UK and the US at Cambridge and Columbia. Prolific columnist and book author. He has written numerous books on copyright. He has served on, or he is currently serving on boards and has received numerous civil and academic awards for his work. Dr. Emily Laidlaw is a law professor at the University of Calgary, where she is Canada Research Chair in Cybersecurity Law. She has also completed graduate degrees in law at the London School of Economics and has privately practiced as a litigator in Canada before turning to academia full-time. Dr. Laidlaw, as a scholar, has actively contributed to law reform and other advisory work, and most notably, she co-chaired the expert advisory panel on online safety appointed by the Government of Canada. But that's not what we're going to be talking about today. Dr. Laidlaw has also been recognized as a Peak Scholar for the impact of her work outside of academia. So we're extraordinarily privileged today to have with us two academics, but two extraordinarily engaged academics, if I could put it that way, to talk about the regulation of online streaming in a free and democratic society. So with their permission, I'm going to be referring to them both as Emily and Michael. So that's what I'll do, but the audience, I think, recognizes how deep the expertise and knowledge of our panelists are this morning. Okay, so just to start things off, I'm going to set a bit of the background and current context of Bill C-11. Bill C-11 is a bill of the 44th Parliament. As probably most participants in the audience would know, it was preceded by Bill C-10 of the 43rd Parliament, also entitled An Act to Amend the Broadcasting Act and to make related and consequential amendments to other acts. Bill C-10 died on the order paper following the call of a general federal election. And so C-11 was introduced in only February of this year. It progressed very quickly through the House, including in the Senate Committee on Canadian Heritage, Patrimoine Canada, where it emerged in June of 2022. And since that time, the Senate has been reading and studying this bill, including a pre-study process by the Senate Transport and Communications Committee. The study by the Transport and Communications Committee of the Senate is ongoing. It's not known yet whether the work of the Transport Committee and the resulting report of the Transport Committee will be available before the Senate rises just before the Christmas break. But to set the stage, that's where the current bill lies. So the government is obviously pushing this bill forward as a priority with some haste. The Senate has taken the time that it needs to deliberate on it, and many witnesses have come before the various committees and of both the House of Commons and the Senate to testify, including both of our esteemed panelists. So this conference is dedicated to promoting discussion and debate around internet regulation, and the title of this opening panel is regulation of online streaming in a free and democratic society. We know from the preface or the summary of Bill C-11 that, among other things, it seeks to add online undertakings as a distinct class of broadcasting undertakings, and seeks to ensure that these undertakings make the greatest practicable use of Canadian creative and other human resources in the creation, production, and presentation of broadcast programming. It also intends to apply to social media programs uploaded by users if the programs are prescribed by CRTC regulation. And the bill proposes to update the broadcasting policy for Canada to make room for currently underrepresented segments of Canadian society in the Canadian broadcasting system. So perhaps we can ease into this topic this morning by a general question, perhaps a slightly normative question of what does this bill get right, and where does it tread on dangerous ground in your study of this bill?
All right, Emily's pointing at me, so I'll start. Sure. So thanks for that, Monica. It's a real pleasure to join both you and Emily on the podcast. It's a topic obviously I've talked a lot about, and you're two of the best people to talk about these issues. You've both been on my podcast, so it's fun to get to talk again in this context. Yeah. So, well, anyone who's followed this or who has followed anything that I've had to say for the last while on C-10 before and C-11 now will know that I've been pretty critical of the bill, and very critical, I guess. And generally speaking, I must admit, I don't think it gets a lot right. You know, there are some. I think the fact that we are examining the Broadcasting Act and seeking to update it, I think, is a very positive thing. I think the fact that definitions of CanCon appear to be part of the scope of what might be reconsidered, I think, is a good thing. And I think the general intent of saying that we recognize the broadcasting world has changed, and so we need to bring internet-related services or provide greater certainty about how we might regulate those services, I think is a good thing as well. I would say, though, that my list of what's not great about the bill is far, far longer. We'll talk more about user content, I'm sure, soon. And so I think that the fact that it extends the scope of broadcast regulation, I would argue, into user content in this way, which I see as just a core expression issue, I think is enormously problematic. I'm also, I must admit, not wholly convinced that its approach to some of the large streaming services is ideal either. That's not to say that I don't think there isn't an appropriate role for regulation of large streaming services, but it has such an aggressive approach with respect to a jurisdictional approach, basically saying that any service anywhere is theoretically subject to this. And the notion that somehow Netflix is indistinguishable from, say, CTV or Global, and so we ought to regulate it in the same way, I just think is wrong. And that's not to say that there shouldn't be some kinds of regulations on some of those services, but they're not the same. And the notion that this is creating a level playing field, I think is false. But there's lots more to talk about. I'll just close my opening by saying that, you know, the ship has sailed on some of those issues, but where some of these issues still remain I think front and center, certainly before the Senate hearings that you talked about, especially is sort of those broader implications around internet regulation, particularly individual speech.
You know, I agree with everything that Michael just said, and so I might not dwell on it. I actually liked the question where you flip things and ask what got right, because it made me pause to try to think through precisely where they might have hit the mark. And I'd say that at this stage, the objective of modernizing broadcasting legislation and regulation generally is critical. What has caused concern for me is all the subjects that Michael mentioned that we'll be diving into. In particular, the area that I look at so much is user-generated content and social media, and so that's really my entryway of interest with Bill C-11. But what has given me more general pause about this is I don't understand why, when this is so critical to push forward, that we need this modernization, there hasn't been more thoughtful discourse and kind of engagement with some of the feedback about the concerns about, the regulatory structure, how this intersects with internet regulation more generally. How this really is quite different when we look at different types of platforms like Netflix, or when we're trying to think through, what TikTok is and whether it fits with any of this at all. Because, there are so many implications and ripple effects. And I think that Chris, in his, remarks this morning, was noting just all these different legal developments going on. So it's not just about Bill C-11, it's about all the different bills that we're going to be talking about with this conference today, and they intersect in some ways that might be unpredictable, but we kind of need to think through.
Mm-hmm. Mm-hmm. All right. Well, thank you for those opening thoughts. I guess we may as well get to wrestling with the biggest elephant in the C-11 room. Which is user-generated content. I think everyone will remember that in the era of C-10, the elephant then was the notion of taxation of online streaming services that consumers so dearly loved and have adopted. But it seems like that issue has receded, and instead it's been taken over by the debate, much of it public and in the public sphere, on the apparent foray of the government in Canada to regulate user-generated content, or more particularly the platforms that are home to user-generated content and the exchange of user-generated content. So, for sake of argument, let's just not debate the question of whether or not the government is purporting to do this. Let's just accept, for our purposes today, that the government does intend to regulate the services that host user-generated content, and that therefore user-generated content and the individual programs of user-generated content may be indirectly regulated by the government, in particular the CRTC. Now, just by way of reference point, under the current Broadcasting Act, the CRTC has passed regulations pursuant to which all programming undertakings that control the content that is carried on their programs are responsible for said content, regardless of whether the programming undertaking is a source of the content. Now, again, just to provide a touch point for our discussion, I think it's noteworthy that there's a proposed section sub 2.2 of the new Broadcasting Act would provide exactly the opposite, as I read it, in the case of online undertakings that provide a social media service. So proposed section 2 sub 2.2 would provide that an online undertaking that provides a social media service does not for the purposes of this act, exercise programming control over programs uploaded by a user of the service who is not the provider of the service or the provider's affiliate or the agent or mandatory of either of them. So this deeming provision is then carried over, again, as I read it, to proposed section 9.1, which empowers the commission to establish conditions of service, and section 10, which gives the CRTC regulation making power, which I'm sure we're going to be talking about at some length later on, or at different points in our talk today. So with this backdrop, and I know both of you have strong views on the issue of user-generated content under the Act. What's at stake here?
You know, if it's okay, I almost want to pull the discussion back first, because to get into what's at stake and to get into some of that minutia, I think, of user-generated content, we almost need to think first about what it is that we're trying to regulate here. And I think that the starting point with broadcasting regulation is that you know, it's always been exceptional in nature. Like, the justification for this type of regulation and the impact it has on freedom of expression has been about points of, you know, promoting and protecting Canadian culture. It's about spectrum scarcity. It's also been just about basic points that things like television and radio were kind of pushed into your home in a way that individuals didn't really have as much control over in the same way they would have in picking out a newspaper that they want to read, or picking up a pamphlet, or whatever else it is out there, right? So broadcasting regulation has always been somewhat extraordinary in nature. And that means that it's not light touch regulation in the least. That's just not how it operates. So what we're looking at now then, of course, is modernizing it in the context of kind of the new consumption and creative space that exists now with the internet. Fine, this kind of modernization is absolutely key. But it's really difficult to layer on top of internet regulation, which has, you know, certain driving principles behind it that, you know, we have to be faithful to, which is that the internet, generally speaking, has been open, right? It has been a space that is relatively free-flowing, that has been innovative and encouraged different types of kind of creativity, and it has been global in nature. And the global aspect of it is so important because, you know, I sympathize with the arguments in response to this, where we say, well, it's global in nature. We have to think through what the impact of Canadian law would be globally. And some of the responses are often, yeah, but it doesn't mean that domestically we can't pass laws on this. That's absolutely correct. It just has to be done delicately and sensitively to what the potential impact might be and how that might interact, right? So if we impose laws in Canada that are, you know, deeply focused just on Canada, it might have a negative impact on creators that actually have global audiences, for example, and we might get into digital first creators in a little bit. So it can have this ripple effect, and we have to think through not only in terms of, well, how does this work with other trade agreements, but, you know, how does this disrupt the internet ecosystem generally? And so I think that from there, that then becomes a key point once we start trying to dig deep specifically on user-generated content, because I think that there's the internet regulation discussion point, which we can have there about what happens when you try to regulate TikToks and YouTubes in this nature. And then we have a very kind of legal discussion we can have about how does this comply with the charter and the right to freedom of expression? Would this actually survive a constitutional challenge?
I'll pick up that. I mean, I think that those are great points, and I think that for a bill that has spent so much time at committee, especially at the Senate, the lack of discussion around some of those questions, I think, is inexcusable, quite frankly. Um, I, I'm struggling to even know where to begin because there's a lot to say, but I want to pick up just on, I guess, a couple of things. One, I must admit, I don't want to let the government off the hook so easily and to
Uh-huh.
sort of say, this is what's an intent. I'm willing to give, benefit of the doubt as much as possible, but if we're honest about it, the heritage minister has not been honest about this, and I find that exceptionally disturbing because so many creators, quite frankly, have come forward, not just the platform, but creators, other experts, all made it very clear that their read of this is pretty plain in terms of the fact that the government has left the door open to the CRTC to establish some conditions and regulations over user content. And so the government's insistence that there's nothing there, I think not only undermines the process and public confidence in the legislation, but I think it's caused enormous harm to the CRTC. And I'm not one that typically is out there trying to defend the CRTC, to be sure. But there was a piece in the Globe and Mail over the weekend talking about TikTokers and YouTubers who have been successful who are now contemplating leaving the country if this passes as is. And we can get into why, if you like, why that would be, why the approach of imposing discoverability rules onto user content actually is likely to cause significant harm to those creators. And I think it's an important point that clearly has been lost on the government. But in that same piece, you had the CRTC say they hope TikTokers follow the website and participate in the process as they establish rules around registration. I should pause there to say, literally, we have the CRTC talking about people who post TikTok videos contemplating registering that content with the CRTC. This alone is craziness. But beyond that, in the same piece, you've got the heritage minister saying, oh, no, there's nothing to see here. And I think, we've seen that regularly, where the minister says there's nothing to see here. Ian Scott, to his credit, has appeared multiple times before committee and made it clear what the legislation says. Same on algorithms, where the government says algorithms aren't touched. Scott says otherwise. You might want to know that just in the last 2 hours, the Senate committees put forward its calendar for next week, and that it includes an hour and a half with the CRTC again. And so I'm pretty sure these questions will come up again. The CRTC will answer them truthfully again. And so I think Scott and the CRTC have been put in a very difficult position because they read the legislation as I think most people read it, and the government has turned this into something that it's not in terms of some of their answers. And I think that really hurts our broader policy objectives. I can stop there if you want, but if we have time, I really do want to get into this question because it's not intuitive for people. It's not always necessarily intuitive for everyone as to why the imposition of what are called discoverability rules on user content actually are likely to backfire on many individual creators, and why so many of them are speaking out.
Yeah, no, I think I'm going to let you continue, but just to interject one clarification. So what I'm hearing is a concern about discoverability rules potentially being imposed on user-generated content platforms, and freedom of expression concerns. And I just want to clarify whether in both of your minds those two issues are flip sides of the same coin. Are those related concerns? Is that the principal concern? And that's sort of what I was driving at when I asked, what's at stake in this discussion about user-generated content and whether they should be regulated under this extraordinary piece of remedial legislation. So maybe if you just answer that and then carry on.
Sure, I can answer. Well, I'd be happy to. I think that they are certainly correlated. I think part of expression is not just the ability to speak, but the ability to be heard. And the ability to be heard can be maybe negatively implicated by some of these discoverability rules. So I do think there's quite clearly an expression piece. I think, as Emily pointed out, broadcast regulation is speech regulation, something that was seen as necessary in a world of scarcity. I think that we haven't seen a compelling argument as to why we should extend those same kinds of principles into a user content world. But I also think some of the most successful people involved right now in Canadian culture are at stake. If we had well-known Canadian singers or actors saying, we're really troubled with what the government is doing with a piece of legislation and we're thinking about moving, I don't think the response of the heritage minister would be to say, oh, they got nothing to worry about and there's nothing here. People would be paying attention and saying there's something wrong if we are literally raising the possibility of driving a really fast growing part of our cultural economy out of the country. And yet that's precisely what's happening. We see the heritage minister denying it. We see the ISED minister, ISI minister Champagne, who clearly is focused on digital economy issues, silent as if this is not his issue at all. This is like an alarm bell that is ringing. And if we are genuinely concerned about the so-called telling Canadian stories and a successful cultural economy, we have people who are right now some of the most successful in this sector, drawing global audiences, exporting the Canadian story all around the world. And they're saying, if you go ahead with this, we don't know if we can continue to practice our craft in Canada. That's what's at stake.
Well, if it's okay if I jump in here, I think that one of the issues here, well, I mean, I agree with Michael here that it's the idea that this is all correlated, right? And I think one of the issues that we need to unpack, and maybe we can do a bit here, is we toss around the idea and this word, freedom of expression, without then digging into the different ways that it's implicated, right? So the freedom of expression at its base is the idea that you have the right to seek, receive, and impart information and ideas regardless of frontiers. Like, this is the basic right. So it's so it has a lot of elements to it. It's the idea that you can search out information, that you can receive that information, that you can impart those ideas. And so when Michael is exploring these ideas of discoverability, the specific regulations that have been put in place put rules around what can be sought and received and how these creators can then impart their ideas. We at least can acknowledge up front that this is a form of speech regulation, and then it can be a discussion point about, are there, is this justified in some way? Is the objective strong enough, and is it correlated to broadcasting regulation? But we never end up getting that far. I mean, there are people trying to have these discussions, and Michael has done that very actively from the beginning, right? But it's not being engaged with. It's just, well, this has nothing to do with freedom of expression. And I think one of the first steps to talk about is, what precisely are we trying to regulate here when we're looking at user-generated content and social media? The Act doesn't even define social media, which is in itself problematic because social media is just a million different things, right? Are they really just writing a law here that is a YouTube law, right? Or a TikTok law? Okay, because then in not defining social media, they could end up capturing all kinds of different kind of audiovisual content that wasn't intended, and creates a real regulatory burden for the CRTC, where so much of this has been kicked to sort of figure out later what is in scope and what is outside of scope. But there's the base question too about, why exactly is user-generated content captured here? Like, what precisely is the objective? And I think one issue is thinking through the different roles that these players play, if we can call it that. They're not always acting in the capacity of a host of user-generated content, right? So, I mean, I'm strongly of the view that all user-generated content should not be included in this legislation. It makes absolutely no sense given the way the internet works. But let's think through precisely what is being targeted here. I mean, there's different capacities of the YouTubes of the world, and to the extent that they have different, contractual relationships or licensing arrangements, this is with particular users who post. I don't see that as user-generated content, strictly speaking. I don't even think it fits into that category. This is commercial content that they have some sort of contract that they've set out certain rights of access to. There's a commercial arrangement, fine, right? But the different sort of organic nature of the content that people post, even if it's monetized in some way, I mean, some Canadian version of like the Holderness family or something, right? Are they suddenly going to be captured by this? Yeah, presumably. But why? Like, why would they be captured by this? Because they don't fit the traditional notions of broadcasting. So the objective has to be clear about what the target is of them, and what qualifies as generating or not generating revenue. And a lot of people who post this type of content, I mean, they start doing it personally, some of it's sort of professional, some of it's mixed together. Sometimes they start figuring out, hey, I can kind of make some money from this. Like, it's not clear, that line between one thing or the other. And why? Because this isn't some kind of television program. This isn't some, finely tuned piece until it reaches a certain level of commercial activity. And even then, it's really hard to compare that kind of user-generated social media content, and you think of the millions of posts that are out there, to this sort of slick production and control that we're talking about when you think of traditional television and broadcasting.
Okay, so there is a ton to unpack, but I guess the key message is the key message that I'm hearing from both of you is that you think that there's a lot of unorthodoxies here, and that there is a lot that has been miscommunicated or is unclear, including what is the objective being pursued by purporting to capture user-generated content platforms or services within the scope of the act. I take your point about the lack of clear communication or selling by the government of its proposals in relation to this. I'm struck by section 9.1 sub 6, which clearly states that the discoverability provisions in 9.1 1A to D are not supposed to apply at all, right? The discoverability powers are not supposed to apply at all to programming that the platform doesn't control. And then if you cross-reference that to section 2.2 or 2 sub 2.2, I think that's the link that I guess completes the exemption from discoverability regulation for user-generated content platforms. Similarly, on the theme of free expression, the Commission has a wide power, which we can unpack if we have concerns about that under section 10. But section 10.1c is clearly within the drafting, within its existing drafting, clearly states that, again, 10.1c is not to apply to programming over which the service has no programming control, which I think must be a reference to user-generated content or social media content. I completely agree with you that it's highly unorthodox to not define a term like social media in a piece of legislation like this, but that if that's the intent, perhaps it doesn't seem that the government has actually effectively communicated that, okay, it's not discoverability, it's not to impose content standards, and so what's left, I guess, is some kind of funding, some sort of funding obligation on the part of user-generated content or so-called social media services. But if after 9 months of constant debate and untold witnesses coming forward that hasn't been communicated and that hasn't been debated or scrutinized, then there's clearly a misunderstanding about the scope of this legislation. But just to close out this topic and before we move on, can I put it to you then that in your view, the definitions in the Broadcasting Act should make it clear that none of these types of services or content should be regulated, and then just close that chapter? Or do you think like this very convoluted exception, exemption, definition of no programming control type scheme, which is the approach that the government seems to want to take with respect to user generated content, could work? Is it a question of it's just not done right, or is it a question of no, this type of service should just simply not fall within the definition of broadcasting?
No, we can come to the question of whether or not it should fall within the definition. I'm sorry, but respectfully, my read is very different of the bill. Section 9.1, the discoverability provision, is 9.1e, involving the presentation of programs and programming services for selection by the public, including showcasing and discoverability of Canadian programs and programming services. People should understand that the definition of programs is really anything. It's anything any audiovisual content. And so in fact, this provision is even more than just discoverability. Discoverability is an example of the CRTC power. It extends to presentation of program and programming services, which could of course extend to things like requiring warning labels for certain content, or even demotion of certain content in the way that it's promoted. It isn't just about CanCon. But more to the point, Monica, you referenced sub 6, which you said then takes it out. It doesn't. Sub 6 says orders made under any paragraph 1A to D. It doesn't cover E. It doesn't cover the discoverability provision. And so my read of this bill is apparently pretty different than yours. It is fundamentally about the content. And a number of times I've heard you say platforms, you keep inserting it. It's about user-generated content platforms. Sorry. The platforms will be forced to execute on some of these issues. The content being regulated are the individual content themselves. TikTok's analysis says it's any video that has music on it, as an example.
Well, and I think that raises the issue that I'd love to dwell on for a second, which is these key insertions about the commitment to freedom of expression, and that this is a priority in any interpretation or exercise the power of the CRTC or any interpretation of any provisions in Bill C-11. Fine, but that doesn't give me a lot of comfort here that on the ground that tells us what to do. For one thing, the fact that all user-generated content by default is a program, and then there are exceptions that sort of remove it, is just totally unprecedented. And it's frankly inappropriate for that to be in broadcasting legislation, period. And I think that itself might be a real constitutional hurdle for this legislation if it was challenged, because there'd have to be some sort of justification to use exceptional broadcasting legislation to scope it all in to begin with, to then sort of create these exceptions after that. What is the basis that all the different ways that we engage and participate in the world, which now happens to happen online, is suddenly scoped in, but we'll create exceptions? And as you can see in the discussion between the two of you, all kinds of different confusion and like uncertainty about what's in and out, uncertainty about the power of the CRTC. But more fundamentally, just tossing out the word freedom of expression, as though we clearly know in law what that means to be able to tell us the scope of these provisions is not true. And I think one of the issues that we have in Canada is that our jurisprudence on freedom of expression isn't particularly developed. And it's in particular not developed when it comes to exploring what the meaning and the protections and limits are when it comes to low value expression, right? And I say low value expression because we say, okay, we can point at political speech, or we can point at different types of speech and say this has high value, right? But when working through that jurisprudence, the courts tend to almost select values because it's not done at the first stage of Section 2B. It's just sort of this proportionality analysis. Now, none of this is about broadcasting right now, but it is about understanding the breadth and the limits of the right to freedom of expression. We now, where's the everyday ways? How are the rights that we express ourselves when we post low value TikTok videos, maybe that have a commercial element, in this sort of space? We don't know, right? And when we try to then transfer that to something like broadcasting legislation, which is then reaching into the arm of social media, we really are in territory where there isn't a lot of guidance. So then saying, oh, but we should take account of freedom of expression really enables regulators to hide behind the cloak of proportionality and freedom of expression in an environment which is still really about selecting values, right? They end up selecting values, but there's no principled basis for that analysis. And that's what's worrying me right now.
Okay, I truly appreciate like getting into it with you both. I think you raise some issues that are relate basically to the structure of this legislation and that go to like the whole scheme of the act and how it's designed, and that certainly goes beyond just this issue of the provisions that relate to social media. But do we have time for just your quick thoughts in okay, if it's not broadcasting legislation where we should be dealing with UGC because not all of it is even UGC is broadcasting audiovisual. What, if anything, about UGC do you think should be regulated, and by whom? Quickly, if I can get you to do that.
I got excited and didn't unmute properly. Platform regulation is like its own field of law, right? And so I think we need to stop thinking about it as like one silo, right? We have to think of it more in terms of, I mean, it would be almost looking at like tort law or like contract law that delves into all these different areas. And one of the most, so what we need to look at and say is, well, there's a competition law element. There's a privacy element here too. There's an online harms element to this. And that to take on platform regulation, which we absolutely should, it really is about looking at the entire landscape of all the different laws that are engaged in like national security legislation, et cetera, to say, where are the different spokes of responsibility and how do we kind of develop this in a way that makes a lot of sense? I think one of the most concerning things I've seen with Bill C-11 debates is where you see a bleeding of topics where individuals argue that, oh, platforms aren't accountable, hate speech is bad, and that means we can justify it through this one step in regulation and broadcasting legislation. And that's absolutely incorrect. We need to be dealing with this specific narrow area of the law that we need to be engaging with and then go from there.
Yeah, 100% agree. Listen, there's already regulation on user content. Copyright law applies to user content. Hate applies to user content. Defamation applies to user content, like it applies to anything. But your question seems to presuppose, is there a role for broadcasting regulation on user content? And my answer would be no. I mean, should this Zoom be regulated? You're broadcasting to large numbers of people who are watching this. Should we have a CanCon requirement? I mean, you have Canadian speakers. What if you brought in non-Canadian speakers? Is there any reason at all that the CRTC should have a role for what I say or what you say or what anyone has to say as part of this broadcasted event? And the idea that we would bring it into that system, even if it is viewed as potentially competitive, still strikes me as a non-starter, because it moves us directly into basic rights of expression, for which the CRTC nor the government should not be stepping.
Yes, our news and information programming. All right. Thank you so much. Let's move on to, because we've only got 15 minutes left. So let's move on to looking at this broadcasting legislative proposal and its intended effect on large online undertakings that provide their own programming. So there's proposals to impose discoverability requirements, funding requirements, exhibition requirements with respect to CanCon, which the CRTC has yet to define. So what is any of this controversial, or should it be controversial in your minds in the context of professionally produced audiovisual content?
Well, I'll start by saying it depends which. I mean, you laid out several different things. I don't know. We're at the point where if this was nothing more than saying Netflix needs to put a banner with Canadian content, or a bar that has Canadian content, I don't think anybody is going to get too worked up about it. If this was exhibition requirements, quota that required a certain amount of Canadian content, absolutely. The simple reality is there isn't enough good Canadian content, all respect to great Canadian producers, for Netflix and Disney and Amazon and all the other streaming services to be able to license without having the effect of forcing them, frankly, to limit the scope of what Canadians are able to access. Because it can't sit alongside if you have, say, a 30% requirement, for example, of Canadian content. And I don't believe that we've seen a few groups who have lobbied for something along these lines, but I'm hopeful that that's not what the government has in mind. But if they were to require, let's say, a 30% CanCon requirement, there isn't enough content. Netflix has got a 5,000 to 6,000 title library. You're going to tell me that they can find 2,000 titles of Canadian content that are worth licensing and available to license, and Amazon can do the same and Disney can do the same? Of course they can't. And so the effect of that kind of requirement, when you have services that are not like broadcasters, that's part of the problem with this thing. They're not the same. And so the idea that you'd impose in your library, you have these kind of exhibition requirements, you can't force people to watch it, even though sometimes before the Senate, you do hear senators say, we would like to force it. They don't get enough of it. Keep making an analogy that, they get their ice cream and they're not getting their broccoli, and somehow Quebec music has become broccoli. I don't think it's a particularly apt analogy, but the idea is we should be able to force people to listen or to watch things. I think that's a non-starter, and requirements that might result in forcing services to remove user choice, because they effectively, the CanCon exhibition requirements set a threshold on how much non-Canadian content you should absolutely be controversial.
Yeah, Emily, do you have anything to add?
No, I don't really have much to add to Michael's comment, so I might leave it there.
All right. Well, how about let me put this to you. So Bill C-11 does not purport to say how the exhibition requirements, discoverability requirements would have to be implemented, but it does suggest that the CRTC would have the ability to determine it may impose these kinds of requirements. Now, as I understand it, C-27 proposes transparency as an organizing principle of the oversight of artificial intelligence. and dealing with personal information. So on the theme of, looking at these issues of internet regulation, proposed internet regulation holistically, how do you see any potential conflict between, say how discoverability mandates under Bill C-11 would apply to online undertakings versus the proposed amendments to privacy legislation? Or is there some way to reconcile those?
So I would say that this is a difficult one, and I know something that we were all talking about, right? And I would say that there are a lot of unknowns right now, right? So the AI Act, with Bill C-27, it's pretty empty, right? It everything is left to be dealt with later in regulations. But what we do know is that as a regulatory structure, it's targeting high impact systems. And so my first reaction is to think through, were you asking specifically about the AI Act element of it?
Sure.
Yeah. Sorry, that's where my mind was, and I realized that maybe it wasn't your specific question about it, but because I keep thinking about if there's specific algorithmic requirements that are going to be imposed out of this, right? And how is this going to work? Well, you would have essentially a minister and potentially someone underneath them that would have oversight of high impact systems. So to the extent that it might be high impact system, they might cross wires with what the obligations might be under Bill C-11. So high risk of this happening, maybe not entirely, but the process, the structure of like who has power, how it will be exercised and in what direction, that is where there might be some sort of difficulty. And I've seen I've had the same questions about the intersection with online harms, right? The second that you start taking on these sort of algorithmic systems, but you're splitting oversight and the risks of monetary penalties across these different parties with oversight over the same system, that is a recipe for chaos.
Yeah. Okay.
Yeah, I agree with what Emily had to say, especially with the intersection with C-27. I'll just say on the issue of algorithms and C-11, there's, I think, two quick points to make. One, government, it's another illustration or another example of the government saying one thing and doing something else in the bill. So it says algorithms are out, and there is in fact a provision that talks about the CRTC not being able to dictate specific algorithmic choices. But when Ian Scott appeared before Senate committee, he made it clear that, well, no, of course algorithms are still in. They're not in the sense that I can tell a platform what to do with its algorithm. I think the way he put it was, I won't tell you what to do with the algorithm. I'm going to tell you to fix the algorithm. So not specify the algorithmic change, but specify that there should be effectively an algorithmic change by the platform. It strikes me as a distinction without a difference, and I think it was understood as such. So it does get into that. And that does allow me to very quickly note that the way these algorithms function, especially for user content, is likely to be exceptionally harmful to Canadian creators. Because if you do have the CRTC effectively mandating algorithmic change in what people see in their TikTok or YouTube feeds, leaving aside that it's at this stage, we don't even know how you identify what's Canadian or what isn't. But those feeds are driven by user interest. They're not driven by a regulatory fiat. And once you start inserting regulatory choice into what people see in their feeds, it's likely that it's going to be some content that people just aren't interested in, because frankly, the platforms know more about what people are interested in than does the CRTC. And if that's where we find ourselves, people are not going to click on that content, or if they do, they won't watch it to completion. The signal sent to the platforms is it's not good content. And the impact of that for Canadian creators is that it gets demoted on a global basis, because when presented to people, they haven't watched it. And so that's why there is this huge risk of trying to take something that seems like, well, why shouldn't we want to try to promote Canadian content, to recognize that it's a fundamental misunderstanding of how this internet-based content and algorithms intersect, and what happens when you're trying to deliver to a market not of 35 or 38 million people, but of 2 billion people. And the impact for Canadian creators, quite frankly, could be devastating.
And let me piggyback on that because I think that's such a crucial point. And I think it does tie back to the freedom of expression point, because one thing that I have been wrestling with here is, is this a form of almost compelled speech, right? That this, we're not, regulating the algorithm, but we're regulating essentially the algorithmic output. So are you mandating then almost like tobacco health warnings, right? Is this sort of like this algorithmic output that is an important health warning telling Canadians that, smoking is really bad for you, right? And as we know, it was, the first case on that found that it was unconstitutional to impose those types of health warnings. And then the second case held that they were constitutional. But what was interrogated so closely by the court? It was, how important is this objective? What is the objective? Does it actually achieve those goals? Like, is this narrowly scoped in a way that is delivering on these pressing and substantial objectives and done in a way that is proportionate? But that is then where I think Michael's points about it's not just about Canadian, pushing Canadian content, is then the impact on these Canadian creators that it's going to backfire. These then become those really important points about it, making it much more difficult to justify compelling a certain result by these providers. So I will leave that there.
Thank you for taking. Yeah, I got bumped off, but thank you, because I think you have led the discussion to where I want to go next, which is to link the algorithms and regulation of algorithms to freedom of expression issues. I don't see any questions from the audience, and we have just 3 minutes left. And so I want to give you an opportunity to touch on a theme that you both referred to in your opening there, and that's extraterritoriality and the ambition of this bill to apply to online undertakings wherever they may be. So that Bill C-11 doesn't expressly state that it will have extraterritorial effect. It is a piece of federal legislation. And so, it can state that it has extraterritorial effect. It does not state that, but it's arguably necessarily implicit that it will have that effect. I note with interest that the CHPC committee did amend Section 3 sub 1A of the Act to provide that the Canadian broadcasting system is a single system, and that it does include foreign and online broadcasting undertakings, and that the expectation is that they will contribute to the implementation of the Canadian broadcasting policy. I know that you're both probably familiar with the USMCA digital trade provisions, the cultural exemption. I guess there's a rule with an exemption and then a further exemption. But quickly, can the audience have your thoughts on that aspect of this legislation?
I'll just very quickly respond by saying the overreach is frankly stunning. And it will, I guess, fall to the CRTC to establish some kind of rational limits. But the starting point is that this applies to everyone everywhere. And the idea that somehow our regulator that our government should be saying our regulator has that kind of power over any streaming service, literally anywhere in the world. And we should note that there are many services that are niche or that are servicing particular communities, especially in a domestic level outside of Canada, but still may have some Canadian subscribers, may touch Canada in some way. The government repeatedly voted against any attempt to create thresholds in the legislation that would have made clear exemptions of certain kinds of services. So it wanted to reserve that kind of flexibility. And I think it's a mistake, in part because once you start moving into a world where if Canada says we have jurisdiction over everybody anywhere in the world when it comes to a streaming service, there's nothing to stop other countries from asserting much the same kind of thing. And that's not to say that we shouldn't be asserting jurisdiction over those services that have a direct impact, a material impact in Canada. But I think it fell to the government, or should have fallen to the government in this bill, to provide greater guidance into how they might define them.
Yeah, I agree. And if we don't want this to be the blueprint for a law elsewhere that will negatively impact Canadian creators, then it should, cause some reflection about whether we want that in Canada, right? And I don't think we do. I mean, the ripple effect of this is going to be negative. In terms of trade specifically, I wrestle with that, and I guess the premise is the idea that they're, facilitating these cross-border data flows, and this manipulates this in a different way. That may be legitimate. It might fail for other reasons that we've explored this last hour. But I would be turning to a trade lawyer, because I think it's almost a very specific question about, look, is this legitimate or trade distorting? And on that point, I'm not certain what the answer is.
All right. Thank you both so much for being so engaged in this discussion that you have had many, many times over the past a year, maybe longer. I'm going to now pass the baton on to my colleague, Julie Fanchen, to discuss the feasibility of reforming privacy law while continuing to foster innovation. Thank you both so much, Dr. Laidlaw and Dr. Geist.